Hello, everyone, and welcome to your first lecture on the judicial process course. This is Unit 1, Law and Politics. And the main theme here is to give you an overview of the subject matter itself that we're studying here, because the course is called, it is about judicial politics. It is about the way the court system is organized and what lawyers do and so forth. But this is kind of a theoretical orientation to it because we have to talk a bit about how we're studying this. You see, law and politics are very closely related in the American system, and in a number of ways. And that's kind of what we're going to talk about, and it explains why we're doing what we're doing and how we're doing it. Historically, in the U.S., important social and political controversies very often become legal disputes. In other words, these are things that are going on in the society or in the political system, and they end up in the courts. And I'll explain a bit why that is. But the point is, this draws the courts directly into making decisions that have enormous political consequences. And that is why David O'Brien, a very well-known political scientist who writes about the courts, refers to the U.S. Supreme Court as the storm center of American politics, meaning it's at the center of the storm. If you've ever seen a picture of a hurricane, it swirls around, and in the center, there's sort of the center of the storm, the eye of the hurricane, that everything whirls around. And I think that's kind of what he's saying. And also, there are many formal and informal connections between the world of law and courts and the world of politics. And I'm going to go through a number of those for you. Let me just give you an example of what I'm talking about. Back in 2015, the U.S. Supreme Court made a decision called Obergefell versus Hodges, in which they said that the U.S. Constitution protects the right of same-sex couples to get married. And that meant that with that U.S. Supreme Court decision, all 50 states were required to allow and to legally recognize marriages between people of the same sex, regardless of what their state laws already said. In most or many states, it was not legal, and then it became legal because the Supreme Court imposed that rule on the whole country. Why? Because it's based in the U.S. Constitution, which covers the whole country. And what's interesting about it, for our conversation right now, is that the majority opinion, which was written by former Justice Anthony Kennedy, if you read the language of it, particularly the conclusion of it, it includes a lot of language that really don't sound like legal argumentation. They sound more like political or philosophical argumentation. Now, of course, the decision is based on a reading of the Constitution. It's based on the due process of law. It's based on equal protection of the laws. It's based on the right to privacy. It's based on a number of things in different ways. And I'm not expecting you to read the opinion and analyze it, but we have other courses for that. But to look at a couple of the interesting intersections here of law and politics, this is one of them. This is from his opinion. He says, no union is more profound than marriage, and he talks about the highest ideals of love, fidelity, etc. And he explains that the people who wanted to get married, the same-sex couple who wanted to get married in a state that wouldn't allow it, actually placed a very high value on the idea of marriage. And in saying this, he's countering the argument made against requiring same-sex marriage. The argument was, well, if this is allowed, then it will be bad for the institution of marriage. And Kennedy responds to that, and that's not really as much a legal argument. It is a political argument, And Kennedy just responds to it and says that's not true. The men and women who want to get married to people of their own sex, he says, they respect the institution of marriage so deeply that they seek to find its fulfillment for themselves. And then he says, they ask for equal dignity in the eyes of the law. The Constitution grants them that right. So if you read this little passage, you can see that he is responding directly to many of the political and philosophical arguments that were not really strictly legal arguments. And I think that's important as an example of the ways in which many courts, especially the U.S. Supreme Court, often really seem to be stepping outside pure legal argument and really talking in the realm of philosophy and politics. Now, most recently, there was the case of Dobbs versus Jackson Women's Health Organization. This is the 2022 decision that reversed Roe versus Wade and wiped out the right to obtain abortions. And I think this is an interesting thing to note because often Supreme Court decisions and also laws passed by legislatures produce public reactions. And those public reactions to the Supreme Court decisions and to other laws can affect elections. And so one of the possible arguments, and that's why there's an opinion poll here showing that there are an awful lot of people who felt that the Supreme Court decision to overturn Roe versus Wade was a bad decision, and so it is. Then people begin to say, well, how will that shift in public opinion? The fact that people are now angry at the Supreme Court, how might that impact the election of November 2022? See, so again, you see legal decisions having political consequences, legal decisions framed in political terms. So I think this is kind of an interesting sort of evidence that these two fields, law and politics, are not really as separated as many people would like us to believe. And so in the course, we're going to be talking about a combination of legal materials and social science materials. We'll be talking about law, courts, judges, the law. It's like having two different communities that could teach us things. Lawyers, judges, and law professors, there are things they can teach us. There are things we can learn. If you go to law school, of course, you'll hear a lot from them. And so let's get, a little bit familiarized with how that works. But also political and other social scientists in criminal justice and criminology, communications, sociology, psychology, economics. They also have a lot to tell us about the law and courts. And so we're going to talk about a lot of that. Now, this is not a case law course where you read, cases and decisions by the Supreme Court, but we'll talk about some of those. And we'll talk about issues and many different kinds of distinctions, like what do we mean by substantive law versus procedural law? The law of crimes, like what constitutes the crime of murder, versus the procedural question of how does a trial work? How does an appeal work? Well, we're going to talk about a lot of that, and you'll learn a lot about court procedures here. We'll talk about the difference between civil and criminal justice. We will talk about ordinary cases. You'll do some court observation and see how ordinary cases are handled. We'll talk about what we mean by precedent-setting cases and how policies really are often made by courts. We'll talk mostly about the U.S. It's mainly about the United States, but we will have some discussion of what they do in other countries as well. We'll spend quite a bit of time really learning about how the criminal justice system works in France, which I think is a very interesting example of a very different way of handling criminal cases than ours. It helps us understand our own. And we'll talk about inequality. We are not going to assume that we're all equal before the law. I think that the argument that everyone in this country is equal before the law, that's an ideal. That's something we supposedly aspire to, but it's not true. It's just simply not true. There are many people who aspire to actually be above the law, and so that the law does not apply to them. And there are also, as we all know, many kinds of inequalities that are built into the law, and we're going to talk about that. And lastly, there's a term I'll use from time to time, legal pluralism. And that is that's a social science term, and it means a situation where you have more than one legal system of laws, rules, etc., operating at the same time and place. Two systems operating at the same time. And I'll give you an example of that. Hong Kong and China. Hong Kong was a British colony for about 150 years. And then the United Kingdom returned it to China in 1997 pursuant to an agreement that they had made sometime earlier. But what happened here was, for a long time, for 150 years, the Hong Kong legal system was part of the British legal system. And so it still had and still has many characteristics of the British common law system, which is what ours is derived from. Due process of law, civil liberties, protection of defendants against the power of government. Well, the Chinese legal system, which now has authority over Hong Kong, is very different. It is a socialist system. It has very few protections against government power. And defendants really have very few rights in the Chinese system. So how do these two systems interact when they both apply to the same country? That's what we mean by legal pluralism. Two systems operating in the same country. Now, how do you deal with that? See? So there was a policy designed to deal with it called One Country, Two Systems, which was intended to allow Hong Kong to have its own constitution, which was called the Hong Kong Basic Law. And that constitution, the Hong Kong Basic Law, guaranteed those traditional freedoms, the right to protest, freedom of speech, freedom of the press, etc. But previous Chinese officials had said, oh, well, China will not interfere with Hong Kong's democratic development and will protect this or safeguard the rights and freedoms of the residents of Hong Kong for 50 years after 1997. Okay, that's way off in the future, right? But what happened was the Chinese government began to become more and more intrusive in Hong Kong, and just in recent years, they passed a law in 2019 that allowed them to extradite accused Hong Kong residents to mainland China, where they would have no rights in court at all. So, people who were criticizing the Chinese government in Hong Kong could potentially be and were snatched and extradited and brought back to China for trial. And this led to a lot of protests. Many people felt, well, the One Country, Two Systems agreement is being violated by China. They're suppressing political dissent, and they began to crack down. There were huge protests, and they resulted in a crackdown. Arrests, prosecutions, prison sentences, and now Beijing says it has complete jurisdiction over Hong Kong. And there's an example here of a person who, the people who was subjected to this new policy. So that's how that arrangement of legal pluralism really terminated, in essence, where China just simply said, we are going to impose our rules on you regardless of the agreement. And I'm not going to get into all the legalities of that in international law, but it's certainly caused tremendous conflict in Hong Kong, and a number of people have been imprisoned. But then the question I'd pose to you is, do we have legal pluralism in the U.S.? Now, we don't really have, we do have state law systems and federal law systems. So under our system of federalism, there's always, every place you go in the United States, you always have basically two legal systems, but that arrangement has really been worked out, and that's called federalism. And in American government, I'm sure you learned a bit about that. We'll talk a lot about that too, about the state court systems and the federal court systems and how they divide their responsibility. So we do have that. But what about another type of legal pluralism? Do we all live under the same laws? Are we all equal before the law? If police and courts are treating people of color differently than they treat white people, if the wealthy and powerful are treated better than the rest of us, so that they can even escape legal consequences. Are some people above the law? And so if that is true, then are we a nation under one legal system, or do we have, one set of rules for most of us and a separate set of rules for those who are very wealthy and powerful? And I would even pose a larger question, which is the entire question. This question, is the rule of law itself being threatened in this country? For example, we have many instances of law enforcement officers inflicting violence on people that is illegal. We have many cases that I'm sure you're well aware of. People have been killed, beaten by police officers, and the police officers for many years felt that they were not accountable for that. And in some cases, they have been held accountable. There have been actually criminal prosecutions of police officers, but it illustrates the problem. But what about presidents? For example, you remember what happened January 6, 2021, where we have an ex-president, Trump, who was still president at that time, who in essence appears to have been involved in encouraging people to storm the U.S. Capitol. He said he was actually going to go with them. He said, let's go down to the Capitol. And the evidence is emerging, as to exactly what he knew about that and when he knew it. But there's a lot of evidence to suggest that he and certainly many of his supporters, his most high-level supporters, were involved in organizing that whole incursion and attack on the U.S. Capitol to stop the counting of votes. Okay, we'll see how all this ends up. But it is clear that there are people in this country who act as if they could get away with anything. And if that's the case, then do we have one legal system or do we have two? And this is a legitimate question for us to talk about. So, having said that, let's begin to look at the two different ways of looking at the court system and the legal system. Lawyers on the one hand and social scientists on the other study law and courts in different ways. Lawyers, and when you go to law school, you'll see this. Lawyers focus on the law as if it were independent from politics. And that's the position that I'm questioning right there. The idea that the law is independent from politics. I believe it is not. And I think I can establish that. And I think by the end of the course, I think you'll probably agree with me. Law is a system of rules. All right, this is what law is. This is a definition. Law is a system of rules that are made and enforced by government institutions to regulate behavior and resolve conflict in a society. Right there, that is a definition of what we mean by law. A system of rules that are made and enforced by government institutions to regulate behavior and resolve conflict in a society. There's your definition, probably be on the midterm. But see, here's the thing. The court system, are one of the three branches of our system of government. How can they be independent of politics if politics control the government? And we have three branches, legislative, executive, and judicial, and courts are one of the branches of our system of government. So politics, and this is why I say they can't be independent of politics. The kinds of definitions that we use in political science, Harold Lasswell, politics is the question of who gets what, when, and how. It is the processes that determine who gets what, when, and how. Well, guess what? Courts do that. So aren't they part of politics? David Easton, another famous political scientist, he said politics is the authoritative allocation of values, meaning valuable things and property and so forth, for a society. Well, again, the courts are involved in making those determinations and those allocations as well. So they're inevitably part of government, and they're impacted by politics. Now, social scientists, especially political scientists, have never bought this idea that the law is independent from politics. We have never bought that. We see law as embedded in the political system. We say judges and lawyers are people. They're not robots. They're not machines. And we argue, and I think most law professors would admit this too, law is inherently interpretive. The idea that the law says this, that, and the other, and it's very, very clear, and everyone agrees on what the law is and what it means. Oh, please. Clearly that is not the case. Everything about the law is interpretation. So, to a social scientist, courts are inherently political institutions, and we disagree with what the lawyers say. Now, as you know, I am a lawyer and I am also a social scientist. I went to law school. I practiced law for 10 years and more. I have a PhD in political science, etc. I have studied this from both perspectives, and I think they both have a lot to contribute. And that's why I'm not going to dump the legal perspective. I think it is important when we study the law in courts to understand that judges and lawyers are different than legislators, and they are different than presidents, etc. They are trained to see the world in a particular way, and this is important for us to understand, and we will learn about it. They learn to apply the law to resolve disputes that are in front of them, to see things retrospectively. In other words, when lawyers and judges are dealing with a case, it's about things that have already happened. When legislators make laws, they think prospectively. They make laws for the future, you see. Now, also, when lawyers, and particularly judges, are making decisions and making rulings, they are supposed to try. Do they always succeed? No. But they are supposed to try to limit their own subjectivity. They're supposed to try to make a legal decision. Now, legislators never try to do that. Legislators are expected to apply their values. So you see, legal reasoning really is different than political reasoning. You know, they're thinking, in legal reasoning, we think about things that have already happened, and we at least make an attempt, as judges do, to try to get their own personal preferences out of the picture. They try to be objective. They try to make legal decisions. But legislators make decisions about the future, and they don't try to take their values out of it. So you see, that means that courts, although they are political institutions to some extent, understand they are also legal institutions. They are different than the purely political institutions. So that's why I say the only real answer here is they are both political and legal institutions. They're different than the executive and legislative branches. So let's jump through these three positions here. Now, this is the remainder of the presentation, all right? We're going to have a section on the courts as political and governmental institutions, then a quick section on courts as legal institutions, and then a few slides on why they are both. Now, so number one, taking them first, courts as political and governmental institutions. There you go, okay? The year 2000, Bush versus Gore. The Supreme Court picked the President of the United States. So, I mean, when you want to argue that the courts are not political, please, give me a break. But there are many other intersections where law and courts intersect. First, the Constitution. Judicial review. The courts interpret constitutional provisions. They decide what they mean. Well, that's very political. Federalism. Courts are the arbiters of the relationship between the national government and the states. And so this is very important on issues like abortion, the death penalty, same-sex marriage. The question arises again and again of should there be one rule for the whole country that limits the states? So that's political. The executive branch. The courts rule on the limits of executive branch power, the limits of the actions of administrative agencies in the executive branch. And then what about this? Presidents nominate federal judges. That's clearly a political connection, isn't it? On the legislative branch, courts rule on the constitutionality of legislation coming out of Congress, and sometimes legislatures engage in retaliation called jurisdiction stripping. This is former Congressman Steve King from Iowa, where he introduced a bill that he thought would repeal the Supreme Court decision that approved the Affordable Care Act. If you recall, the Supreme Court decided that the Affordable Care Act, also called Obamacare, was constitutional. They left it in place. And Steve King was very angry about that. And he tried to pass legislation that would bar the Supreme Court from citing their own decision in forthcoming rulings. This is very odd, but that's called court stripping. Legislatures, as you will learn, the Congress does have the power to limit the Supreme Court and all the federal courts' jurisdiction in certain matters. We'll talk about that. But that's a way that the Congress can try to retaliate against the Supreme Court that don't like. And they can do other things too. They can, change the size of the Supreme Court, create new courts, abolish courts. You'll learn more about this, but that's a real political interaction. Also in elections, courts make important decisions about election procedures, such as how votes can be counted in Bush versus Gore, what candidates can say, what are the limits of election speech, and many important decisions about the financing of elections, a lot of them. And of course, speaking of elections, in many states, including Illinois, judges are elected. So you can't really separate them from politics if they're elected, can you? Then what about with political parties? Well, the parties are very active in getting people onto the bench and in keeping them off. Best example I can come up with there is the saga of Merrick Garland. In February 13th, 2016, Supreme Court Justice Antonin Scalia died unexpectedly. And about a month later, President Obama nominated Merrick Garland to replace him. Now, that should have resulted in a Senate procedure to either confirm him as a Supreme Court justice or reject him, and they should have voted on it. But Senate Majority Mitch McConnell, Republican, refused even to act on the nomination. This has never happened before. This is unprecedented in American history. And so President Obama could not fill the vacancy because they refused to act on the nomination that he made. And then in 2017, when Trump came into office, he was, of course, was elected in 2016, but he became president in January of 2017, as because of the inauguration on the 20th. He immediately nominated Neil Gorsuch to fill Scalia's spot, and who was immediately confirmed by the Senate. And so there you go. They basically, Mitch McConnell essentially stole the seat. That's very, very political. And this has had huge consequences for us because Gorsuch, if the procedure had been followed, Garland would have been on the court since 2016. And Gorsuch would not be there at all. So, but as a postscript, then when President Biden took office, Biden nominated Garland to be Attorney General, and the Senate confirmed him for that. So he is the Attorney General now instead of being on the Supreme Court. And then in the next year, 2022, Garland's Department of Justice initiated an investigation of Trump for mishandling government documents, and so again I don't know the substance of all this. We don't, as of this recording, but just note the political interchange here that goes on with respect to the law and courts. It's almost unavoidable. And then a couple of more intersections. Interest groups, they're a very powerful force in American politics. Well, you've heard of interest groups, the Sierra Club and Greenpeace and the National Rifle Association and on and on. Well, they don't just lobby the executive branch and the legislative branch, not at all. They're very active in the courts. They find plaintiffs to file lawsuits. They finance their litigation. They contribute money to campaigns and other efforts to influence judicial selection. They file briefs in existing cases, and they try to influence the public to see things the way they want them to see them. And also, there's another intersection of courts and government, public opinion. We believe, political scientists believe, that the courts are influenced by public opinion, no matter how much they deny it. Of course, there's some states where they're elected, but even if they're not, keep in mind that courts have no power to enforce their own decisions. And so they depend on compliance. They depend on our respect for the institution of the judiciary. And so they have to be a little bit careful what they do. So, for example, it has been pointed out that, and we will never be able to prove it for sure because they'll never admit it, but the public from the 90s to over a 20-year period that's depicted on this Gallup survey data, public opinion changed in this country regarding same-sex marriage. You go back to 1995, 96, public opinion was 2-1 against same-sex marriages being held valid. But if you look what happened by 2015, 20 years later, it's about 60-37 in favor of recognizing same-sex marriage. Now, why did public opinion change? Well, probably things happening in the culture. Many things happening in our culture, and it began to change. And so what happened in 2015? The Supreme Court decided Obergefell versus Hodges and said the states must allow same-sex marriage. Now, did the change in public opinion affect the Supreme Court? Social scientists would say probably. If that opinion had not changed, what would they have done? Now, I'm not saying the courts always follow public opinion. They don't. But are they completely divorced from public opinion? Again, I kind of question that. They're human beings. And lastly, the media. We are all influenced by media portrayals of courts. We're going to talk about that. You're going to do a paper on that very issue, media portrayals of the courts, a short paper. They shape our perceptions of the process, and often they mislead us. Sometimes they inform us very well. Other times they mislead us. We'll talk quite a bit about that. So let's talk about the courts as purely legal institutions, okay? Because as I said, it's just not true that the courts are political institutions, yes, but they're not purely political institutions. They're also legal institutions. And I just give you a couple of examples. One main one here. These are a couple of people who, the man on the right, that's Timothy McVeigh. He was a right-wing anti-government terrorist, basically a fascist, who blew up the federal building in Oklahoma City in 1995, and he killed 168 people, including a large number of children who were in a daycare center in the building. Now that's an intensely political act, obviously. He was a terrorist. He was a right-wing terrorist who was acting on an inspiration he got from a book written by basically a Nazi. The book was called the Turner Diaries, and in that book, the government is depicted as evil and treacherous and coming to get your guns and all this nonsense. And he believed all that was going to happen, and apparently, and so he was executed. He was prosecuted. He was executed in 2001, and as it happens, the person who was the prosecutor in charge of that office at the time was Merrick Garland, who's now the Attorney General. He did, I don't, it's just the way it worked out. It happened in Oklahoma City, and that's where the trial took place. But that highlights a number of things. I mean, yeah, his actions were political, but his prosecution was straight by the books. It was just absolutely done in a purely legal manner. And why is that? Well, because lawyers and judges are socialized to do things in a particular way. They all went to law school. They're all socialized into the legal profession, and they all learn to, quote, think like lawyers. And that means a number of things, and we'll talk a bit about legal reasoning right now and more later. But when we talk about law school, we have a whole week on law school and lawyers. But, lawyers are professionally socialized. They can spot each other a mile away. They kind of recognize each other. And there's a number of things that are really interesting about lawyers. One is you're trained to not take advocacy too personally. There's always a cliche about lawyers fighting bitterly in the courtroom and then going out to lunch together or going out afterward, both opposite sides of a case and go have a drink. And the truth is that happens all the time. When I was practicing law, I certainly did it many times. It's just, why? Because lawyers are supposed to be professional advocates, and you underline the word professional. It's a thing that they learn to do. They're not really supposed to be attacking each other personally. They may say things about each other in each other's case, but everyone understands it isn't meant personally, it's handled professionally. At least that's the way it's supposed to be. And that enables lawyers to work out other people's conflicts. The litigants can hate each other. That's okay. If they want to hate each other, they can hate each other. But the lawyers should not hate each other, because the lawyers are going to try to settle and resolve the conflict or litigate it according to rules. And they're not going to hate each other when they do it. They're going to try to do it right. So lawyers have to be able to advocate aggressively, but not take it personally. That's how they resolve conflicts for people. And they're maintaining social order when they do this. When we trust the legal system to resolve our conflicts, we're making our society work better. That's the logic of it. So lawyers need to do these things to be advocates and to be vigorous advocates, but to do it ethically. Now, the other thing is the way they look at things. Legal reasoning is a particular way of viewing a situation. If I tell you a story, you'll listen to the story, and you'll interpret it however you like to interpret things, right? But if you've been to law school and I tell you a story, you tend to see it a particular way. You tend to break it down in a certain way, and you're taught to do this. Like, okay, who are the parties? What are they disagreeing about? What are the issues? What rules can be applied to resolve the conflict, you see? And who can resolve it? So like if it's kind of a silly example, but like, let's say you have a lawyer who is also a parent. And if they're resolving a dispute between two of their children, they'd probably tend to do it that way. Wait, what are you arguing about? Who's arguing? Mary and John, what are you arguing about? And whose toy is it? Well, what rule can we apply? And what would be fair? See, that's a way of looking at things. And a lot of us really do things that way kind of automatically because it's in our culture. But when you go to law school, you really learn to understand conflicts that way. They also are taught that the U.S. Constitution is special, very, very good, and that common law is the best system. Neither of those things are particularly true. In other words, our Constitution is a very old document. It's the oldest constitution still in force in the world. It has a lot of problems. I mean, it has certain good points about it, but it has a lot of problems. And it was created in a time of massive inequality. and it can be used to reinforce and reproduce inequality. It has a lot of problems. And the common law system, which we'll talk a lot more about, is that the best system? Well, I don't know. It's a system, and we'll learn how it works. It's the system we have, but that doesn't mean it's the best. But lawyers are really typically trained to believe that. Well, they're also trained to believe that we are all equal before the law, and I'll tell you flat out, that's simply not true. That is a falsehood. And lawyers are trained to believe that and to act as if legal outcomes are fair because they were done according to procedures. So in a way, as a lawyer, one of the shortcomings of it is that, it's good that you learn how to help people resolve their conflicts. But lawyers are in a position of reinforcing a system that has a lot of problems in it. And so this is a tension that all lawyers have to deal with. It's just part of the game. It's part of the profession. Really neither good nor bad. It is simply the way things are, It is also helpful to think about law and courts as a system. And that means something. And this is a diagram. It comes from a book I used to use in this course by David Neubauer. And you can see in the center the institutions of the law. That is the law, the courts, the executive branch, all the places, the branches of the system. Outside that, you find the judges and the lawyers themselves, the interpreters of the law, the lawyers, the judges, the probation officers, the people with what we call law jobs. Going to the outer ring, the consumers of the law, the people, the businesses, the entities who call the police, the ones who see a lawyer, the ones who file a lawsuit, the ones who provide the inputs and supports into the system. And then outside the system is the environment that the system constantly interacts with. Changing social attitudes, major events, elections. The environment affects the rings on the inside, which is the system. And the system affects the environment. So it's a way of looking at the system, at the legal system as a system, as like an organism almost that exists in an environment, and that has parts to it. Like an animal in the forest, or like an amoeba in a puddle of water, or like a human being. Anything can be looked at as a system that operates in an environment. And the legal system does have its own rules, its own procedures. It tries to perpetuate itself. It has its own values. It's a distinct subject of study. And many of us do study it as a system. And so this is where, in this slide, you can read this over, but that's basically what I just explained. Now, lastly, let's look at the courts as both political and legal institutions. In other words, this is where I think the truth lies, in the intersection of the two. They are the same in some ways, right? They make authoritative decisions about who gets what, when, and how. They settle controversies, many of which are political issues. They choose winners and losers in our society. And their decisions involve discretion and interpretation, and they always have a human element because they're always made by people. And they're different because they're passive. They can't pick and choose their matters they're going to decide. Cases have to be brought to them. They look to the past rather than the future, although interestingly, their rules that they make can apply in the future to other cases. They apply rules, they think a particular way, and even though they are connected to politics, they're also somewhat isolated from politics, a little bit, not completely, but certainly more than the legislative or executive branches. So they are both. All these things are actually true. In other words, all the things we've said about them as political and legal institutions, they're all true. They are both. And as I said, they decide major social and political controversies. How long have they been doing that? Forever. Alexis de Tocqueville, who was 1805 to 1859, French diplomat, traveled around the U.S. in 1831, wrote a famous book called Democracy in America that probably many of you have read or heard of. And he said, back in 1831, or 35, I guess, that there is almost no political question in the U.S. that is not resolved sooner or later into a judicial question. Folks, that was over 190 years ago, okay? I mean, we're close to 200 years ago. And that what was true in 1831 or 35 whenever he wrote it is still true today. Many controversial political issues are decided in the courts by judges. So this is simply the way our system works. So let me give you just a few quick examples and then wrap up here. The powers of the branches of government. I mean, I spoke about this a little earlier, but these are things that are really current issues that are before the Supreme Court or other courts right now. The powers of the branches of government. For example, the power of Congress to regulate the economy, which has been quite expansive since the 1930s. Well, that's under attack in the courts right now. Will the Supreme Court decide that Congress can't run many of these agencies the way they do? The president's power over the bureaucracy, the president's power to control the executive branch bureaucracy. Some say it should be very expansive. Others say it shouldn't. Well, you know where that's going to get decided? In the courts. The powers of the national government and the states, federalism, that's always before the Supreme Court. Economic policies and immigration policies, very, very central. Many important decisions about immigration policies in recent years. The questions of elections and democracy is really coming before the court again and again, and in very important ways. For example, reapportionment, the drawing of legislative districts after every census, every 10 years. This is critical in the balance of power and between the major political parties. And one that many people don't know about yet, which is called the independent state legislature theory, which is a theory that used to be regarded as sort of a crackpot theory that is now, probably going to be heard by the Supreme Court, as to basically allowing state legislatures to, if they want to potentially invalidate the popular vote for president. And say, let's say that, you could have a candidate, let's say, for example, that Kamala Harris runs for president against Ron DeSantis. And let's say that a state like, I don't know, let's say that the state of Kansas, let's imagine that Kamala Harris wins. Under the independent state legislature theory, the Kansas state legislature could simply invalidate that and say, no, DeSantis wins. Now, this is a pretty radical concept, the ability to saying that legislatures can nullify the popular vote. But believe me, there are people claiming that. And they'll try to turn that into a legal issue. You see, could you get that passed through the courts? No. Could you get that passed through legislatures? No, you couldn't, because people, legislatures probably wouldn't even pass that law themselves because they'd be afraid the voters would throw them out of office. But courts can sometimes do things that legislatures can't, and this is not impossible that this could happen. Many, many civil liberties issues, you know about this: criminal justice, exclusionary rule, death penalty, abortion, guns, same-sex marriage, very important civil rights rulings in recent years. So all these things come before the courts. And as we wrap up, I'd just like to point out, again, to conclude, American courts are both legal and political institutions, and therefore we need to study them from both a legal and a political perspective, and that is what we will do in this course. The insights and methods that are used by lawyers and judges are very valuable in understanding most of the things that courts do. Most of them are relatively routine. Most decisions, most cases, relatively routine, and so they tend to be decided according to law. But there are many cases where that doesn't happen, where there's a lot more political significance and potentially a lot more discretion, and often the insights and methods used by political and other social scientists help us to understand at a deeper level some of the things that the courts do, especially in particular cases that are highly politicized by their nature. The last thing is, I'll just point out there are some really good books. I've used textbooks in this course in the past, these two in particular. David Neubauer's book, The Judicial Process, the Banks and O'Brien book. I mentioned David O'Brien. These are good books. If you want to take a look at those, they're in the library. Help yourselves. But the subject and the substance of this course is my own. I've created it, but I've certainly relied to a substantial extent on the works of others, many other people, including these two excellent textbooks that you may, if you want to check out, help yourselves. But the substance of the course is found in the PowerPoint presentations in these lectures. and in the readings that are in the topics, weekly topics folders, all of which have readings in them and videos and other things. And so there you go. So thank you very much for your attention. And as always, if you ever have questions or comments, I love to hear from you. And I hope you will, read this over, think about it, and ask any questions that you may have so that I can help you understand it as we go forward. Thanks a lot. Bye-bye.